Good afternoon, everybody. As it is 12 o'clock on the dot, I'll go ahead and get this legislative and case law update started. First, some housekeeping. My name is David Furman. I'm a partner here with Altitude Community Law, and I want to thank you all for joining us. On your screen, you'll see the PowerPoint presentation in the center of your screen. This should take up most of your screen, so it's all good if it does. There should also be a small box on the bottom right-hand side of the screen with the video feed. I, the presenter, that's me, over here in the right-hand corner. On the left side of your menu, please select the question and answers icon and type all of your questions there, which will be addressed. It says at the end of the webinar, however, if anybody have been to a webinar that I have taught and or any of the classes that I have taught, you know I like to answer questions as they come up, because usually if you have a question, it will lead to another question, and I want to make sure we stay on a topic until we actually get the answers that everybody needs. Remembering, I'm here for you. I want to make sure you get what you need out of this and have fun doing it. So CMCA credits, if you're here for CMCA credits, are automatically generated once the webinar hosting site provides an attendance confirmation report. And these will be sent via email within 48 hours. Following the webinar, these credits are not transferable. They're personal to you, so please don't try. Please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about receiving your CMCA certificates. This webinar is recorded and will be available on our website shortly after we finish. Then we also have an ACE, Altitude Community Education YouTube channel. It'll be posted on that as well. So if you miss something, if you don't hear something, go ahead, go there. It'll be all sorts of fun. Another advisory. This is not legal advice. I'm not your attorney. I hope to be some of the associations you represent's attorney, but as of right this very second, I'm not giving legal advice. And if you have any substantive questions, contact your attorney. With all that fun stuff being said, welcome to what I believe is my 10th annual legislative and case law update. Can't believe I've been doing this stuff this long, but welcome. I'm glad everybody's here. Let's see if I do that right. All right. 2021, the year that wasn't. This legislative season was kind of a pour over from the 2020 legislative season. It was full of COVID. It was full of non-in-person testimony. It was full of all sorts of things that were COVID related. And it started off with the very first bill out of the chute was additional protections for COVID financial related issues. You could kind of tell right from the very beginning where they were going to go. They went there. So a lot of stuff was done. It was also a very good one. There was a lot of debate, a lot happening on a lot of different topics. And it started with, the minority party in place trying to get COVID protections for small businesses or businesses that followed COVID procedures, introducing bills both in the House and in the Senate, and both of those bills failed. And you kind of knew where the state was going to go. The state is also trying to find and address budgetary shortfalls. And as it was trying to find money for budgetary shortfalls, a lot of bills got put on hold or weren't addressed. I will get to that question in just a minute. You got to give me a second. There's a question on the signed bill already. Let's get there. So in session 2021, it was a good one. As we moved into it, you may make up. We have a dominant party. A single party held both houses and the governorship. So anything they wanted to get done could have gotten done with very little resistance. And which is why I make the statement that the one party didn't seem all that worried about giving COVID immunity to businesses, because if they wanted to, it could have gotten done. Okay. We get into the year after COVID. Yeah, it still mattered, guys. The state's still trying to deal with it. This session was still all about COVID-related issues. It started late. They gavelled in on the first day, then they immediately adjourned or took a recess so they could position themselves to better deal with budget issues, position themselves to better deal with the bills that they wanted to pass. It was a strategic move because the state constitution says the legislature can meet for 120 days. A Supreme Court decision last year said it does not have to be consecutive days. That can be broken up during a state of emergency. So when they gavelled in and then immediately recessed, took a break, and then came back in, they could have gone to 6/12 or June 12th. They decided not to do that because they were trying to look at how to spend some COVID money that would come in from the federal government, but they adjourned a little early to see what they could do. So that's where we are, and that was the mindset of the legislation or the legislatures this year. So with that being said, let's see what happened. The bill, the big bill, HB 21-1229. This was a carryover from HB 20-1333 that was introduced last year. It was intended to be a comprehensive Kiowa cleanup bill. It was intended to be a massive overhaul of the Colorado Common Interest Ownership Act. It amended 19 unique sections as introduced. It amended 19 unique sections of the Colorado Common Interest Ownership Act. It would have done or amended 13 different parts within those 19 sections. It added burdens to associations, included increased compliance costs, reporting costs, and reporting costs to the state of Colorado, and included such wonderful things as addressing penalties for failing to provide documents. It addressed conduct of meetings, which we'll all get into this. It addressed requiring associations to upload their declaration with the state, along with all amendments with the state. It required associations to post with the state all of their Section 209.4 disclosures that are required on an annual basis. And this gets to the Section 209.4 disclosures requires the association send out to its owners on an annual basis where you are keeping your declaration, your articles, your bylaws, your rules, regulations, all your governing documents, all your good governance policies, your insurance policies, your insurance policies, your assessments, your assessment by unit type. It also would have required you upload the state. It would require every association to have a website in the state. It would have given the Department of Regulatory Agencies independent investigatory authority and authority on its own motion to go find violations of the Colorado Common Interest Ownership Act. So it really was a very, very, very burdensome bill. So it was fiercely debated. It was, when it was introduced, and as I said, it was, very large and touched all these spaces. It was so widely opposed at the beginning. The sponsor of the bill, after introduction and after introducing a few amendments to try and get support for it, continued to have stakeholder meetings and had a variety of stakeholder meetings to go into how to improve the bill. And what came out of those stakeholders meetings were a series of additional amendments. And it was the amendments of, when it went to hearing, and if anybody attended the initial hearing on HB 21-1229, Representative Titone had amendments ready to go to try and address any questions that might came up with it. She had drafted a number of amendments. And as the bill worked its way through the process, it became increasingly and increasingly more difficult to garner support for the bill. So what came out was the very, very trimmed down HB 1229. And what finally passed was limited to 4 different provisions. Non-vegetative turf grass in the backyards is now protected, meaning every association must allow as part of the xeriscaping plan, non-vegetated turf grass. It didn't put in a whole lot of rules around it, other than it must be allowed and it is now protected and it's in the backyards. My interpretation of this bill is that you must allow non-vegetative turf grass from post to post, meaning the entire backyard can be non-vegetative turf grass. You can adopt standards towards the appearance of the non-vegetative turf grass. It has to be X quality. It has to be this color green or that color green, or must be this type of mix. But you cannot effectively adopt a rule that prohibits it. Solar panels continue to be protected. Solar panels, you must allow them. And if an owner comes up and says, I want to install solar panels, and their initial application sets a baseline price. And with the baseline price, if your rules and regulations either increase that cost by more than 10% or decrease the efficiency of the solar panels by 10%, your rule is no longer enforceable, or your rule cannot be enforced, and you must allow the solar panels to be installed as proposed. So when the application is going to have a baseline efficiency and a baseline price, any of your rules, during the application of any of your rules, if it increases cost or decreases efficiency, those rules become unenforceable. So you'll have to work with the owner to make sure that you are within that window of enforceability. And a question popped up really quick. It says backyard only. What about yards? It is backyards only. So that is the statute specifically says rear yards. So if you're looking at your plat map, whatever's in the back of the house from wing fence to wing fence, that's the backyard. You must allow non-vegetated turf grass. You do not have to allow it in front yards. But any provision in your declaration that outright prohibits non-vegetative turf grass or artificial turf, that is no longer, it's void as an unenforceable and as it violates public policy. Okay, next, disclosure of unique fees to buy a home into a community. By unique fees, this is now part of your section 209.4 disclosures. And you have to tell them annually. And unique fees to buy into a community are, do you have a transfer fee? Do you have working capital fees? Does your management company charge a fee? Those must all now be disclosed on the association's website, must be made available to realtors looking to buy a house in the community. These are, again, consider it just like your declaration. On an annual basis, you must tell owners where to find this information. This information for your section 209.4 disclosures now includes the unique fees to buy a home in the community. Like I said, it's working capital, transfer fees, any other fees that are charged to any owner to buy into that community. They're outside of closing costs, realtors fees. You don't disclose realtor fees. Title company fees, you don't have to disclose those. It's just fees charged by the association or coming to the association. There is now a provision for penalties for failing to produce records upon request. Now, when I say upon request, it is triggered by receipt of the association by a certified letter requesting certain documents. Excuse me. Once you receive that, a 10-day period starts. You have 10 days to produce the records. You have to give it. If, however, 30 days elapse and you still have not produced these records, there is a presumption of damages in the amount of $50 per day that retroactively start on the 11th day. So essentially, you've got a 20-day grace period upon which to provide records. But if you fail to produce on the 30th day, there's a presumption of $50 a day damages that's retroactive to day 11. So right off the bat, if on day 31 the owner claims you have not produced records, damages accrue, and it's $50 a day with a maximum of $500. So it's word to the wise, get on these record requests. Make sure you are adhering to the records requests, and make sure you are, I would say, almost in a way, overly producing. Make sure you're getting everything to them. Owners, they expect these records. Owners want these records, and they are taking great steps to make sure they have access to them. I received just yesterday a lawsuit where the association had produced all the records and the owner sued, claiming they didn't have all the records, and now it's going to a court. So owners are really looking for these records. They want to get these records. So make sure that you are teed up and ready to go, and make sure that, to whatever extent the records are being provided without charge, because most of the records you're required to produce should be readily available, meaning you can just email them. That's as you all know, 317, section 38-33.3-317 was rewritten to allow for email production. Most of these records should be available by email anyway. Make sure you're just shooting them off as quick as possible. Okay. Talked about, time out. Let me see, past solar panels, key takeaways, great. Okay. Before I go on to this next bill, remember that as I first started this conversation, this bill, 1229, and let's go back to it, was drafted mostly in conjunction with, based on 1330. So this is now 2 years in a row that Representative Titone has introduced a bill addressing those provisions that she believes are very important. It's very personal to her. She really wanted to get this bill done. She really wanted to add protections for homeowners that she perceived were being aggrieved. It was very difficult to deal with the drafting of this bill. It was this bill, like I said, being very personal. She was really trying to get traction for the bill. I believe, and this is just purely me, I believe this bill is coming back again for round 3. And it is going to be mandatory arbitration or mandatory mediation before an association is allowed to sue. It is going to contain penalties for associations that fail to operate within the scope of the governing documents. It is going to include protections for homeowners that believe the association is acting inappropriately. So it's, like I said, we're not done with this bill. We're not done with this topic. I believe it's coming back in a new form next year. So come January 3rd, 4th of 2022, get ready to deal with this bill again. It's not going away. These topics are not going away. Associations are going to continue to have to make sure that the association handles these disputes in a way that it does not cause more problems. So again, these are just word to the wise. Get ready for it again. Okay. Question. Sellers also have an obligation to provide the records, and they're trying to pass it off to the managers to perform. Yes, the sellers do have an obligation to do it, but the sellers get the records from the association, and they tell their realtor to go out and get the records from the association. And the records are they're statutorily defined. They are contractually defined. It is these 209.4 disclosures. So, again, it ultimately it's going to fall on the association to make sure these records are in a place that they can be achieved. And when you get a request for the records, you have to be able to provide them. All right. Is an HOA required to purchase docs from the county for any docs they don't have or request for being forwarded? Here, let me see if I can see that full question. There we go. Question is an HOA required to purchase docs from the county for any docs they do not have, or can a requester be forwarded to the county? Well, the association is supposed to have them. I mean, what do you get from the county? You get your declaration. It's a recorded document. You get any amendments to the declaration. It's a recorded document. They are created by the association. The developer during transition is required to give you the recorded document. So you can't forward you cannot refer an owner to the county to go get the declaration. You cannot refer an owner to the county to go get any amendments to the declaration. You are required to have those. And those are the documents that you're supposed to have. You're also supposed to have your articles of incorporation. That is a document of the association that you are required to have. And since you are required to have that, no, you cannot push that burden off onto the owners, because remember, 317 says the association must make available for inspection and copying the association's declaration, articles, bylaws, financial statements, budgets, bylaws, and all of that is required to be retained by the association and made readily available. Again, and getting back to your section 209.4 disclosures, those are part of your section 209.4 disclosures. So you are required to have those readily available. You cannot push an owner off onto the county to go get them. Let me see. Here's a question. Is the new synthetic turf section effective immediately? We do not have time to get with the board to draft something that establishes certain guidelines to install criteria and quality color of turf. In answer to your question, none of this is immediate. And I say that because as of today, the HB 1229 has not even been signed by the President of the Senate, the Speaker of the House. It is not even sitting in front of Governor Polis yet. So to say that it's effective immediately is not accurate. No, it will be signed. We expect Governor Polis to sign it. We expect Governor Polis to enact it into law, and then it will become a law sometime this September, after the period of time that you can refer it to the owners to appear on the ballot in November expires. So I would not expect anything to, well, by definition, it cannot be effective any earlier than this September. So you have time to go establish these criteria. You have time to go forward. But these are some of the things you need to start thinking about. And these are some of the things that you must take into consideration when you are doing this. So go ahead and start compiling your information that you have for the turf grass. Start compiling your information as to what look do you want, what feel do you want, what does the owner have to do in the backyard to install it? Because quite frankly, it is not easy to install this non-vegetative turf grass. It is not like you can just throw it on the existing grass. You actually have to do quite a bit of prep work to be able to put it down so that it lasts. And you can absolutely require that prep work be done. So you don't have to just go through what the owner says. You can say, no, owner, you have to dig in 5 inches of dirt. You have to remove it. You have to put down the turf. You have to put down the base. You have to put down this. You have to amend the soil. You need to make sure that there's drainage. So when your dog goes out onto your yard and does what dogs do, it doesn't smell in the community. You could also require that the turf grass be maintained in a way that prevents smells and prevents odors from accumulating on the turf grass. So again, it's one of those things that it's not as easy as just throwing down, some artificial turf. There does work, and you as boards, you as architectural review committees, you can absolutely go through this process of this is what we're going to do to make sure that it is appropriate, it looks good, it maintains the aesthetics in the community. Another question is regarding making records available. When will websites do, or do we need to produce physical records? No, absolutely. You can refer an owner to your own website, and an owner's going to have password, and you can say, when owner sends a request, you can say, dear owner, they're all on the website, go nuts. And if you can't find something on the website, please let us know, but they are already disclosed. And we have a section on our website labeled Section 209.4 Disclosures. We have a place on our website that says budgets. We have a place on our website that says meeting minutes. You can absolutely have the owner go there and then come back to you with just those documents that may not be there, or specific documents. But you don't have to do the legwork for them if they're already on a website. Okay, next bill, and this is the fun one. This was a late arrival. You would not believe how fast this bill was introduced, how fast this bill was approved, and how fast this bill went along through the system. And a lot of this comes from what had happened during the pandemic last year, during the protests that came on after the shootings, and after the unfortunate situations with the deaths last summer coming into this summer, and with the quick evolution of the Black Lives Matter signs and the police signs, the thin blue line signs. And this bill, the number of complaints that came up through the populace with associations attempting to enforce their sign provisions in their existing declaration. And most declarations state no signs can be in the community. No signs other than a professionally lettered for sale or for rent sign can be in the community. And associations, as they had been trained to do, send out violation letters on the Black Lives Matter signs. They don't comply with the declaration. The associations that did take enforcement action were doing it in good faith in accordance with their declaration. Now, of course, this caught the eye of the media. This caught the eyes of owners in the community, and there were a lot of protests at board meetings and a lot of protests at homeowner associations, the meetings, and they Westward caught the articles and they ran with it, and national stories on associations attempting to enforce what a year ago were not controversial provisions in a declaration. Now, of course, associations also ran into the trouble of, and I did have communities that I advised and I talked to, where if you are going to get rid of signs, it meant getting rid of all signs, not just the ones you liked and not just the ones you don't like, but it meant getting rid of everything. So if you as a community allowed my daughter is an honor student at XYZ high school, or if you were allowing and turning a blind eye to my son's a star football player, or my daughter plays lacrosse, or the congratulations to Jordan for graduating high school, or congratulations to X person for doing this, those were no longer allowed either. Those were signs in the community, and they all violated the statute. Or they all violated, not the statute, but the provisions in your declaration that says no signs. So what popped up was HB 21-1310, and it is labeled as the Freedom of Speech Bill. It flat out says an association cannot limit the content of flags and signs. You can't. You can adopt content neutral rules towards the number of signs or flags on a lot, the aesthetics. They can be professional. You can require they be professionally lettered. You can require they be non-faded, or they have to be in good condition. You can prohibit commercial signs. So if somebody comes up and throws their sign into the ground and says, XYZ Roofing Company did my roof or is doing my roof, you can prohibit that sign. You can prohibit the signs from the contractors doing work inside. You cannot prohibit any other sign. What's the pros of this? Well, it takes the discretion completely and totally out of the association's hands. The association can just throw their hands up and say, you know what, we cannot deal with that sign. Political signs are no longer an issue, or they are no longer protected. So when I said you can adopt a rule regarding the number of signs, the provisions that state one sign per ballot measure per election cycle, displayed no more than 45 days prior to the election, 7 days after, that's gone. Throw those rules out the door. You can restrict the number, location, aesthetics of the sign, the size of the sign, and whether or not it's commercial. You cannot restrict the sign content. Now, the first question I got, which I laughed and said, let me get there, stated. There we go. Regarding making website, wait, time out. I need to go to the question. Sorry, I went to the conversation. There we go. The very first one, our sign rules prohibit profane and inflammatory language. Is that still allowed under HB 21-1310? No, it's not. Content neutral. You cannot restrict profane or inflammatory language. That is not content neutral. Can profanity be prohibited, i.e. F word, whenever political candidate of the moment? No, you cannot. Content neutral. If somebody wants to fly the Confederate flag, they are allowed to fly the Confederate flag. If somebody wants to fly a swastika, they may fly a swastika. If somebody wants to fly a I support Donald Trump 2024 or whenever, you must allow that to be flown. You cannot prohibit the content of a sign. I cannot stress this strong enough. Content neutral. You cannot decide, association, what is good speech, what is bad speech. You may say your Confederate flag cannot be torn. You can say you can only have one. You can say it can be no bigger than 3 by 5. You can say it can't be torn, frayed, freighted. You cannot require its removal otherwise. Now let me jump back to this window and hit this new one. There we go. Sorry guys, I'm toggling between windows. All right. Can you limit location? Yes, you can limit location. You can state it has to be in the front of the sign. The flagpole can be no larger than 20 feet. It cannot be in common area. You can only have one. Those are all fair game. One at a time, content neutral, location, yes, that's all fair games. Are the signs that read, we don't call 911, we call Smith & Wesson? I'm going to go out on a limb and no. That if you try and limit that sign, that is not content neutral. Content neutral. You cannot determine what is good speech, what is bad speech. It's, again, from some aspect, my friends, this is very easy for the association. When you call and get a complaint, my neighbor is flying the Trump 2020, stop the bullshit. That sign is permitted. When you get the call that says, my neighbor is flying XYZ flag, your question should be, is it bigger than 3 by 5? That's it. Signs, same. Signs, flags, consider them one and the same. So every sign is okay? Yes, every sign is okay. As far as content, you can adopt content neutral rules. That is number, aesthetics, no commercial. Oh, sorry, Sandy. When I say every sign is okay, you can prohibit commercial signs, which gets to, are these scare signs for security systems? Are they commercial signs? They're advertising a security company, or are they part of a security system that can't be diminished or can't be restricted? I would argue leave those alone. I think your rules should say every home may have a security sign if they have a security system. All right. Will political restrictions stay the same? No. Again, getting back to, as a compromise to harmonize this bill with the political sign bill, the political rules were taken out entirely. No political sign bill. You cannot, or you don't have to have independent political sign rules anymore. They are no longer protected. One sign if you want, two signs if you want. Number, aesthetics. You cannot prohibit somebody, if they want to start flying their Biden 2024 flag today, they can. Let me see, 2024? Yes, 2024. You can start flying that today. You can put that up now. You cannot restrict signs or flags, period, unless it's number, aesthetic, size. All right. Does that include pride flags? Yes, pride flags are protected. You cannot prohibit pride flags. Okay, we talked about political times. Throw those out. Forget about them. When you say number, does that mean you can only say one sign at a time, or does that mean only one sign, the same sign at a time? Statute says the exact language. Sorry, guys. And again, I'm going to hammer this home. We got 25 more minutes. I'm going to keep it up. The association shall not prohibit or regulate the display of flags on the basis of their subject matter, message, or content, except that the association may prohibit flags bearing commercial message. The association may adopt reasonable, content-neutral rules to regulate the number, location, and size of flags and flagpoles, but shall not prohibit the installation of a flag or flagpole. And then it goes on the sign stuff, separate section, but it reads the same. The association shall not prohibit or regulate the display of window signs or yard signs on the basis of their subject matter, message, or content, except that the association may prohibit signs bearing commercial messages. The association may establish reasonable, content-neutral sign regulations based on their number, placement, or size of the signs or other objective criteria. So, getting back to, can you prohibit, let me see, when you say number, does that mean you can say only one sign at a time, or does that mean only one of the same sign? I think, based on this language, one sign, one flag, period, end of story. All of these other questions. Can the county prohibit signs? Yes, the county can. The association can't. Now, when I say the county can, they probably can't either, because they are subject to the First Amendment. Remember, the whole reason this became an issue is because associations are small, closely held, nonprofit corporations. As a small, closely held nonprofit corporations, the First Amendment did not apply to you. The First Amendment starts off with no government, no state can infringe the freedom of speech. So when the question is, can the county prohibit this stuff? Well, the county can try. The county is subject to the First Amendment. Now, obviously, you have heard arguments that, oh, the Confederate flag is hate speech. Well, great. Let the county decide that, not you, the association. If you have a problem with a flag and the content, go to the county. Do not go to the association. Your hands are tied. Question, what about pornographic signs or flags? What about them? If you try and regulate them, that's not content neutral. Content neutral, size, number, aesthetics, no commercial. Now, if it's a pornographic sign or flag advertising a pornographic company, no. If it is a pornographic sign just saying, I like to do this, you cannot prohibit it. So, for political flags or signs, each neighborhood could require a different size for the candidates. Yes, you could. 3 by 5, 24 by 36, you can adopt towards the size. If you want to allow a 40 by 40 foot sign, go nuts. The county's not going to let you, but you can. Well, I take it back. You can't be more restrictive or least restrictive than what the county says. So you probably need to go back and look at what the county says. Let me bounce over to this question thing real quick. Question. Where did I leave off? Our sign rules prohibit, oh wait, time out. I got that. Can you clarify the political signs as to why they're no longer an issue? If it's for a ballot initiative from 2020, wouldn't that not be relevant? I can go into it, yes, because when this bill becomes effective, and this bill was sent to the governor today, it was sent this morning. I expect him to sign it quickly. If it is from 2020 and you are trying to say get rid of it, that is now not a content neutral rule. You just crossed into content. We don't like the 2020 part. Therefore, that is not content neutral. You have to get rid of it. You can't do that. The minute this bill gets signed, well, not the minute, in September, when this bill becomes effective, these rules come into place. If you try and restrict something from 2020, that is now content. You can no longer touch content. Was the 12? It was passed. It was sent to the governor today. The question was HB 21-1310 passed? Yes. Has it been signed? No. It just went to the governor today. It's going. It will go. We expect him to sign it. Remember, a lot of the signs that were trying to be restricted were politically expedient signs. Black Lives Matter, thin blue line, pride flags. Those are all signs that were politically important last year, politically motivated last year, and that communities came out and tried to restrict. This bill takes this out of your hands. You cannot restrict content. I cannot hammer that enough. Size, appearance, location, number, yes, fair game. Content, no. Nazis, skinheads, pornography, all protected as far as the association goes. You cannot prohibit those. You are going to get complaints. Your speaking must be exactly what is, just as blunt as I am. No, we can't. Sorry. Take it up with the county. Now, as every one of these questions popped up, I have a feeling, and again, this is just my feeling, you're going to see a cleanup bill next year. I think when this goes nuts this year, as I said, hang on, it's going to get interesting. It is. I think you're going to see so many complaints. I think you're going to see so much come up that they're going to revisit this. What were they thinking? I mean, the question is, what were they thinking? Again, they were looking at political expedience, the type of signs that were being restricted. In this house, we believe science matters. We believe this. We believe this. In this house, love trumps hate. The Black Lives Matter signs, the thin blue line signs, they were all first and foremost on everybody's mind. Associations were doing what their declaration said to do and sending violation letters. And therefore, knee-jerk reaction. Associations can't discriminate based on content. That's what they were thinking. Do these approvals apply to renters or only homeowners? All signs and flags for any resident. If it's a tenant and they want to fly, if they go get it professionally lettered, they want to fly "My landlord sucks," or more likely, "I hate my association." That's not content neutral. You cannot restrict that sign as long as it's within the sign parameters. You can also say they can't be lit, other than the American flag. You get where I'm going, guys. You cannot forget about what's on the sign. Get at the appearance. Get at the location. Get at the number. Get at the signs. That's what you can get at. You cannot get at what's on the message on it. Remove that from your psyche. That's off the table now. All right. How small a maximum size are you and your altitude friends willing to defend? That's a really good question. It has to be reasonable. Is all I can tell you is if you want to try and get down to, like I said, what are standard political signs? They're 24 by 36. Maybe you get away with something smaller than that. Maybe I wouldn't go any smaller. A standard American flag is 3 by 5. I'd kind of leave it at that. Reasonable rules. Can we ask the neighbors of can you ask for people to sign? I'm leaving those names out, my friend. Yeah, you can. Let's put it this way. What's good for the goose is good for the gander. And if the board wants to put a sign up that says, "I hate my neighbors," they can put that sign up. Or "My neighbor's a jackass," you can put that sign up too. Content neutral. Size. That's what's out there. That's where you are. Yeah, you're going to get complaints. You are. And like I said, it completely and totally takes this argument out of your hands. The board can literally say, is it professionally lettered? Is it smaller than 3 by 5? Is it frayed or damaged? If it's not any of those things, forget it. I would adopt a sign policy that supersedes what's in your declaration, starting effective, like I said, call it September. I cannot imagine this bill is not going to get signed. It flew through on bipartisan support, because remember, not only were one party's signs being discriminated against, the other ones were too. So it was an equal message. Associations cannot restrict speech. Period. End of story. Does this apply to a commercial HOA office building? Sure does. But you guys are going to have different sign requirements anyway. So again, you can't content speech. If it's in the association can't do it. Now, obviously, if it's in a commercial context or a mixed-use context, you're gonna be able to put more pressure on the commercial owner, because they have to invite people in. They're trying to get people in, and go from there. Let me see. Flip over to this one. The line of C states that content-neutral reasonable restrictions can address the number, placement, size, or other objective factors. Yes, objective factors. That's why I'm getting condition. It doesn't say everything, every comment we've talked about is content. And it has to be content neutral. If you're going to try and adopt a rule that says no pornography, that's content. Tasteful, that's content. You can say it has to be all white. You can say, or all black, or the lettering can't be neon. Those are objective factors. The lettering has to be professionally done. It has to be, if you want, you could put in, say it has to be the base color of the house. Something along those lines. You cannot restrict the message. You just can't. Can the HOA urge respect and courtesy in neighborhood? I would highly recommend you do that. In your rule, say, we do these things and we encourage all owners to be respectful of their neighbors, because that's all you can do. You can encourage it. Okay, let me bounce over to this one. Here, okay. That's new synthetic surf. Should they still say they need written permission from the ACC? If you want to require written permission, yes. But again, it's going to go to the factors of size, placement, location, flagpole. Yes, you can absolutely do that. Again, can you adopt these objective criteria to the background of the sign must be X color? Yeah, I think you can. You can't have neon. Yeah, I think so. Again, those are objective standards that are not based on content. They are, we don't want neon pink signs in the community. We don't want neon blue. We don't want, we don't want those type of signs. We want, nice, professionally lettered, good condition, white, black background, opposing front in the lettering. Yeah, I think you can do that. All right, any more? Let me get a couple more questions on this. Then I can do a real quick rundown on the case. It's not like there was a whole lot going on in the course this year. Are time limits on signs now disallowed? Yep, sure are. You cannot restrict that. If they have a right to flag, if they have a right to display it, you cannot restrict the timing on it. I don't see how you do that. Saying you can only fly this. Now, remember, you can still have seasonal decorations and the lights and all. Those aren't signs. And the big Santa, those aren't, not there. What about the U.S. flag policy? The U.S. flag policy, nothing has changed as far as the U.S. flag. That's still part of the flag. That's still part of it has to be flown in accordance with the flag code. You can still regulate the size. You can still regulate the flag pole where it's located. Again, nothing's changed as far as the U.S. flag. What you've really done is you've added all these other wonderful flags into it. Okay. Holiday lights. There you go. Homeowners celebrate multiple holiday lights are being kept up year round. Yeah, they sure are. Sorry, it's you can state, winter solstice season. Let's say Holidays normally celebrated with the winter can be displayed Thanksgiving the week after Christmas, something along those lines. Decorations, holiday decorations, still, around the holiday, that type of stuff. Those are still fair game because those are not signs. And those are not, lights are not signs, decorations are not signs. You don't have to worry about those things. Those you can still address. It's literally the sign containing a message. That's what you can no longer get at. All right, let me move on for just real quick, and then I can always come back if needed. As I said, the courts were really, retainage. This is another really important one. Very little play. Nobody really picked up on this bill, but 21-1167 has already been signed into law. It is effective. And I make the slide comment that since contractors must be protected against themselves, any retainage in a contract greater than 5% is unenforceable. I don't know why. Well, I know why the bill came into play. It's because associations were driving harder bargains. This isn't just association contracts. This is all construction contracts. They were demanding more and more retainage because contractors were creating bigger and bigger checklists. So the statute flat out says anything greater than 5% is unenforceable. I think what we're going to have to do is start looking at smaller percentages down. You're going to have to start getting your punch list done quicker so you don't have this very, very large punch list at the end of your contract that a 5% retainage may no longer be sufficient to cover. Also get your lien waivers right up front. Make sure that when you are doing this, you are handling your business and taking care of it. It's almost a pay-as-you-go type contract situation because you can't have a 10% retainage sitting at the end of your contract. That's just gone. So that's for all contracts. Again, as soon as the bill is effective, that's for all contracts moving forward. Okay. Discrimination, HB 21-1108 adds gender identity and gender expression to the protected classes under the state's version of the FHA. So it's, marital status, familial status. You can't discriminate based on color, race, creed. Now gender identity and gender expression are protected classes under the state's version of the FHA. So it's not part of the federal statute, but it is part of the state statute that mirrors the federal statute. Again, just be really careful with dealing with gender identity and gender expression. It's now a protected class, could give rise to a discrimination claim. And that pretty much sums up what happened in the legislative session. Real quick onto the cases. Really not much going on this year as far as appellate cases relating to associations. Only one out of Colorado was Woodbridge Condominium Association v. Lo Viento Blanco LLC. It had to do with a prescriptive easement case. And you can obtain a prescriptive easement under the mere adverse use in the prescriptive easement context. It only required a showing of the use made without consent or other unauthorization of the landowner. To obtain title to it, you had to show a few more factors. But to obtain just an easement, all somebody has to show is that somebody was using the property without consent or authorization of the landowner. And the reason I put this in, one, is it happened to do an association. In association, they were using property they didn't own to access common areas. So that was kind of into the community. It was a little weird shape. They were going across property they didn't own to get to their maintenance facility. Been using it for years and years and years and years and years. Open, notorious, without permission. And the landowner tried to develop the property, said, hey, that's my property. Association sued to obtain at least an easement in it and was victorious. And I bring this up again. If you've got a situation where you've got neighbors coming across your property without permission and have been doing it for an extended period of time, it may result in they have obtained a prescriptive easement and you can no longer control the use of that property. It's what happened in this case. And I do know a couple associations where that has happened, where they were required to grant a prescriptive easement to somebody because they'd been using it forever to access wherever they were accessing, and it disallowed the association from controlling that piece of property. So if you have an area that's being used by the general public and it's not supposed to be, you may want to shut that off, or at least put signs says, authorized used only, or close it off, or say, here, owner, public, you can come use it, because that'll stop it, because one of the threshold is without consent. Another case, Escadante 1 Corporation v. Ocean 3. And this, it was involved, it's out of Florida, but it involved the scope of a release of a property, the parties in a construction defect case. And what the case did is Escadante owned the penthouse unit in a condominium complex, and the complex, massive water leak and continual water leak on this roof. And the owner sued the developer in construction defects, sued the association for failing to fix it. The association settled for $350,000 worth of damage, signed a release, and a couple years later, it was still leaking. And the owner came back and sued again and said, my roof still leaks, you owe me more money. And the association said, no, you signed away all these claims. And the release had language of past and future claims. So the court said, nah, you in fact did sign away all your rights as to this water leak. And you, owner, has said in your testimony that the leak never stopped. Therefore, it was all one leak, and you are now stopped. And the funny thing in this case, again, is this is really an extended scope of the lease or release. So if you have a water leak or if you have any issue and you settle the release, make sure, one, from the association's point of view, is as expansive as possible. And the second piece of that is make sure that it is tied to an event. So if any future damage is tied to that same event, it's still going to be released. And like I said, it was really great. But the interesting thing about this case, as we wind down real quick, is that the developer claimed or admitted in its construction defect settlement that the roof was unfixable. It could not possibly be fixed. And that testimony was used in the second case, saying, we never fixed the roof. We can't fix the roof. You acknowledge the roof is unfixable, which is why the developer settled with you for $2 million and essentially paid you everything you had in the unit. They paid it back to you because they just gave them the purchase price of the unit back. But the developer didn't even want the unit back because it was deemed unfixable. So I kind of laugh and say, wow, this company got a little greedy because it settled for mass amounts, maintained the unit, and then said, pay me more. All right. Then McGrath v. Duncrest, and I'll blow through this one real quick. It's an FHA discrimination case. And it's went into constructive denial of a reasonable modification request. In this case, the owners of the community wanted to add a second exit to their unit because they had two disabled adult children that needed a second exit. After 2 years of negotiation and after 2 years of dealing with the association voted 5-3 to grant the reasonable modification to allow the door to be built, the second exit to be built. And then questions came up as to, could the board really vote that, because it was done in such a way that apparently one board member's mom voted or a board member's daughter voted on behalf of the mom, and questions came up, and the people that didn't want to see this happen rejected it. And the association said, this is an internal governance issue. We granted permission, but it's an internal governance issue, so this FHA doesn't apply, because there's a case out that said discrimination doesn't apply until you actually deny the request. Court came in and said, yeah, nice try. It's been 2+ years. You had to fill out approval paperwork for these people to go get a permit. By failing to fill out the paperwork and acknowledge you voted in favor of it, you have denied it, and it allowed the case to move forward. So it really became a contentious issue. And again, it gets to, when you're dealing with reasonable accommodations, make sure you're doing it prudently, quickly, and make sure you're documenting everything. And just because you say they can do something, if you don't give them permission, they can't do it. Or fill out all the paperwork. Now let's go back to a few questions. If the documents are available on the website for the homeowners of third-party entities, like title companies, condo deck or associations online requests, let me see, it keeps going. Can you charge a fee to provide them the documents to them? Yes, you can charge a fee for any work you provide to them, because really what you are selling is you are selling an estoppel certificate to the owner for buying in your community. You're providing them the estoppel certificate that all the documents are current and accurate. So if they're going out and getting it themselves, you haven't provided that guarantee they're accurate. So yes, you can sell that quasi insurance policy that everything's guaranteed and accurate. What happened to 1229? It just has not been sent to the governor yet. It's the president of the Senate and Speaker of the House have not signed it. It has passed. I expect it to go shortly or soon. It just has not been sent to the governor yet. We do expect once it goes to the governor, it will be signed. Again, it's in la la land right now. Should HOA pool bathrooms no longer be labeled men and women due to HB 1108? I think you can still label men and women. You just can't discriminate from the person that goes in it. If I identify as a man, I'm going in the men's room. If I identify as a woman, that's my gender identity. I can go in the women's room. You can't fine or prohibit somebody from going into the bathroom of their choice. You can still label men and women. You just can't prevent somebody from going into the bathroom of their choice. How do we handle complaints about signs that one may find offensive? I would argue you give them the finger. No, I'm kidding. Don't do that. You respond very professionally. We are prohibited from adopting rules for offensive signs. We're sorry you deem it offensive. The person that flies it doesn't. We're prohibited from doing. We're prohibited from adopting or enforcing rules based on that offense. You just, again, your hands are tied. It's out of, you cannot do content anymore. All right, getting back to, let me see, I think I go down here. Hey, I own in that HOA. I don't know which HOA. Any signs on manager licensing? Good question. There was a sunrise report request for manager licensing. The report will be prepared over the next X number of months. It will be delivered to the legislature next year for action. I cannot imagine this governor allowing manager licensing, or quite frankly, this legislative body pick it up and address it again, since it has been vetoed. So while I can tell you there is a sunrise report being done, I can also tell you that the fact that this governor vetoed it, the continuation of manager licensing, I would find it hard pressed to find it coming back ever again, based on that veto. And with that, guys, it is 1:03. Thank you so very much for attending and the very lively discussion. Stay tuned. Like I said, your rules, we're going to have to amend your rules. Start getting prepared for it. Start getting all your signed policies ready to go, and then get ready for the complaints. They're going to come. I know it. You know it. We'll just deal with it when they get there. So thank you so much, everybody. Have a wonderful, wonderful day.